So we are ready to start our first panel, which is more like a revised version of curved dais in comparison with the roundtable we had, and where it's going to be a little bit more, if I may, anarchical, because we're going to let the panelists run the show as much as possible. The point here is not for me to be boring my students with what they already can get from me, but to hear from the experts that are on the trenches in DC right now and their amazing experience and discussion. Just a very brief comment. In light of Judge Gordon's remark about the history of the CIT, and Larry's comments about how much gets done in terms of trade in New York City, it should be clear that the name of the present panel, Trade Administration and Enforcement, a DC update, needs some qualification. To help us on that qualification, let me ask the members of the audience, what was the first case tried in the United States by a judge appointed to the first court organized in our nation? Anybody know that? What was the first case tried in the United States by a judge appointed to the first court organized in the land? Yes, Heather Doherty is absolutely right. Yes. Well, there were a couple of hints, right? If the question being asked in a trade and customs law conference is enough of a clue, those who thought trade or customs case are absolutely correct. The first case tried in the new courts of the United States on Tuesday, November 3rd, 1789, to be specific, had to do with the amount of customs duty on certain iron-made imports. Interestingly enough, United States v. 3 boxes of ironmongery. I'll repeat, United States v. versus 3 boxes of ironmongery. Ironmongery is basically a general term that describes things made out of iron, stuff made out of iron, utensils, I guess. Was tried before District Court of New York, Judge James Duane, an appointee of President George Washington. Even more interesting, Duane Street is where the CIT now sits, just across the street to what became the Southern District of New York. And Judge Gordon, if he were here, he would actually compliment, because I mentioned this last night to him. And he said, and there's something more interesting about that. Apparently, the first case was supposed to be with the District of New Jersey, but something happened, and then the first case ended up being in New York. But it's a fairly interesting part of town. We should all get to know. So yes, much of trade lawyering is done in D.C. The Federal Circuit is located there. Sorry? I'm here. It's not all. Oh, right. So yes, much of trade law is done in D.C. The Federal Circuit is located there, but as much as it hurts for me, a Boston team fan, to recognize New York City is not the only home of the CIT, but the birthplace of U.S. trade law and litigation. With this qualification out of the way, of course, as our customs colleagues are correct to remind us, trade law is practiced everywhere in the land, everywhere in the United States, but the court of first resort, the subject matter specific court in the CIT in New York City. With this qualification out of the way, our speakers in this panel operate out of our nation's capital and are well-seasoned experts on what happens in present-day Duane Street. Okay, so now let's talk a little bit how we are set up for today. What we're going to have is a very brief 5-minute or longer if they want. They run the show. The initial remarks by each of our guests. And then following these remarks, they're going to have a curved table, if you will, discussion. And then we're going to provide for more time for audience questions this time around. So let me start with by introducing our first speaker, James Cannon. Jim Cannon is an international trade attorney and partner in the law firm of Cassidy Levy USA, Kent, USA, LP in Washington, D.C. For over 30 years, Mr. Cannon has been involved in diverse international trade matters, including anti-dumping and countervailing duty cases, escape clause actions, exportation of controlled commodities. Mr. Cannon regularly appears before the U.S. Department of Commerce, the International Trade Commission, the Bureau of Customs and Border Protection, the U.S. Trade Representative in various federal courts. Our next, following Mr. Cannon, we're going to have Michelle Lynch, who might not remember me when I was a very junior associate, shaking in my legs when I came to my first hearing, and I had to present some issues, and I was introduced to her at the Department of Commerce. Michelle Lynch is Assistant Chief Counsel for Litigation in the Office of Chief Counsel for the Trade Enforcement and Compliance at the U.S. Department of Commerce. Her responsibilities since joining Commerce in 2001 include trade and U.S. Court of Appeals for the federal representation before Court of International Trade and U.S. Court of Appeals for the Federal Circuit. She's also instrumental in the government's defense of administrative determinations before NAFTA panels, various World Trade Organization panels, and the WTO appellate body. Ms. Lynch is an active member of the Court of International Trade's Rules Advisory Committee and is on the board of the Customs and International Trade Bar Association. Prior to her experience with the Department of with the Department of Commerce, she was a trial attorney with the Department of Justice, and Ms. Lynch is also a graduate of Guilford College and the George Washington University Law School. And finally, our final member of our distinguished DC expert panel, Dominic Bianchi, General Counsel of the United States Trade Commission. He serves as the Trade Commission's chief legal advisor. In his office, he provides legal advice and support to the commissioners and U.S. ITC staff on investigations and research studies. They also represent the ITC in all litigation involving determinations and activities, as well as providing assistance and advice on administrative law matters. We briefly touched upon this. The ITC also has a system of administrative law judges. Besides its tremendous work on trade remedies and preparing reports for Congress. It's an amazingly busy agency, just as Commerce is. Prior to his appointment, Mr. Bianchi has served in several roles at the ITC, including acting General Counsel, Chief of Staff under Chairman Dina Tanner Oken, and Congressional Relations Officer. He practiced at our now defunct firm, our sweet old Dewey Ballantyne. I never thought I would refer to Dewey like this, but I miss those days. I do miss those days very much. Bianchi holds a Juris Doctor degree from Georgetown University Law Center and a Bachelor of Science from Northwestern University. Please join me in welcome our wonderful
Good morning. My name is Jim Cannon. I'm with the law firm of Cassidy Levy Kent. Initial disclosure, I am a protectionist. Now, I want to talk about essentially three things. First, kind of the policy balance right now. The title of the overall conference was Changing Times. We are in some changing times, and when we talk about a DC update, I think it's relevant to start there. Secondly, I want to talk about some of the more recent changes to U.S. laws, both legislatively and in decisions, that implement this balance. And then thirdly, I want to talk just briefly about the WTO, and then I'll quit. So I'm a lawyer. So how many of you here are law students? Raise your hand. Okay, so I actually have some practicing lawyers too. Or the rest of you professors. If you're a practicing lawyer, raise your hand. Okay. So I'm just trying to figure out, so of the law students, do you know anything? Have you taken an international trade course? 3. If I say anti-dumping, does anyone know what I'm talking about? 3 or 4. Okay. So I need to, okay. I'm just trying to gauge how basic do I need to be.
Jim, I think they think you're going to call them.
I am going to call them. That'll get us through the day, right?
Some of them did not raise their hand.
So you heard Judge Gordon, and I just told you I was a protectionist, so let's bring back the whips. Okay. Now, having said that, we also heard Professor Colares, and he interestingly cited an economist for the concept that free trade is in and protectionism is out. Okay. Now, we all know, and I'm now talking about my first point, policy balance. We all know because we watch elections, debates, or maybe we don't. But we all know that trade is actually, the word has been used on television. Now, I've been practicing trade law for, I don't know, a long time. Over 30 years. So trade has never been, maybe a top 10 even issue. In fact, I saw a presentation on this at another conference a couple of years ago, and there was a PowerPoint, and it was showing they were polling Americans, and trade issues never rose above like number 8 in the list. And now both candidates actually talk about it. So this is a change, right? It is current. It is somewhat different. But don't be fooled. The protectionists are not happy. Okay? There is not sort of a massive shift. There is a balance, and there always has been, and it's built in. Right? It's built into the system. So on the one hand, as a lawyer, and I represent a lot of U.S. companies in Ohio, in Warren, and in Cleveland, in fact. Brush-Wellman's just up the road. As a U.S. attorney who represents U.S. companies, you know, it actually makes me feel good if I bring a trade case and I keep some imports out of the United States, and one of those factories puts 400 people back to work, right? I certainly do not lose sleep over that. I feel great about that. Now, in truth, I will also disclose I represent some Chinese too. I represent some foreign companies. I represent U.S. companies who import, because we live in a complicated world. You aren't on one side or this or the other, right? You're a multinational. You import, you also make here. So, but truth is, like, I don't, you know, if 400 people went back to work in China, yeah, I don't know how I feel. Not so great. These are my personal views, obviously. Having said that, there is this balance, and the balance plays out in our policy and in a DC update. An update might be that while we are focused on this in the election, it doesn't mean that by any means the imperative for free trade, so to speak, writ large, you know, is gone. In fact, an example of that is the TPP. Okay, so in Washington we use acronyms. That's the Trans-Pacific Partnership. You guys have heard of this? Okay. I always worry when I go to court. I always worry about using all the DC acronyms whether the judges actually know what we're talking about. At any rate, so both presidential candidates have bashed this. We should not be doing it, okay? Well, right now, while we're in the lame duck session, I can tell you there is absolutely an active program underway to pass it, and it very well could, right? And we have a bunch of clients. There are major, the Business Roundtable, the U.S. Chamber, the National Association of Manufacturers even. There are major forces in corporate America who want to see that pass. And that interest group is still out there, and it very well could. I mean, it could happen. You know, lots of things could happen. I'm just, by way of saying that the balance still exists, right? You may hear more about one side or the other, but it's still there. So let's talk about an update on legislation. So what you do see is how the balance works in the recent legislation. So in 2015, we had the Trade Preferences Extension Act, and that was sort of a good example of a package that brought this together. So we have we want to get another acronym, TPA, right? Trade Promotion Authority. Old people call this fast track. We wanted to get this in the law so that we could negotiate the TPP. The trade-off for that was we had to add some other elements to the package. And whenever Congress passes Trade Promotion Authority, they'll always be implementing legislation and it'll have some goals, and some of those will be protectionist goals, because that's how you buy the votes to get the whole package into law. So in the implementing legislation on the Trade Preferences Extension Act, on the one hand, you had AGOA, the African Growth and Opportunity Act. You had GSP extension. So these are rules that provide for duty-free treatment of imports. On the other hand, you had changes to the injury test applied by the ITC, which made it easier to show captive production. Okay, this is a very key issue to one industry, the U.S. steel industry, and that's why it's in the law, and it made a change that makes it easier to invoke this provision. We had changes to the way we implement at Commerce the dumping law. And an example would be now we don't have to make sales below cost allegations. It eases our burden as private litigants. The agency automatically has to investigate this. Or we had another change to the injury test at the ITC, where the Commission now has to consider profit in a whole variety of ways. That's explicit in the law. Actually, they used to do it, but now it's explicit in the law. Yeah, I wouldn't have paid very much for that legislation myself, but you know. Another big change. Another change we had is in this mix, right? Oh, I'm sorry. So that is an example, the Trade Preferences Extension Act, of this balance, right? So the macro balance that we talk about in public, in the policy, in the speeches, gets reflected in this more micro level of U.S. legislation, which actually, in this package, you see the balance actually literally written into our law. Then we also had another statute passed called Enforce, which tasks customs with sort of getting tough on imports, with enforcing trade remedies more effectively. In that, you might look at that and say, well, there's sort of a victory for the protectionist side, right? Because they're getting this law written, which is going to make things, it's going to improve enforcement, so to speak. Well, that remains to be seen. The regulation's only now being written. A lot have been said about it. That the procedures they've set up are, at the moment at least, almost illusory. The first case that was filed, they didn't even initiate, and it's unclear that the agency that administers this has any enthusiasm. So whether or not the Congress must have passed a law and say, yeah, get a little more protectionist, it's entirely unclear that's what's going to happen with the administration. Now I'd like to move from that to some of the decisions, some of the more recent decisions. And so in the context of a DC update, and thinking in terms of this, theme, how we're balancing, there are several cases which illustrate the U.S. approach, and that it sort of works both ways. So one area is what we call scope. So in dumping and countervailing duty cases, which apply to price discrimination or subsidies, you have to define the scope of the case, what product is included, right? And there are some very broadly written cases. One of them that's famous is aluminum extrusions. It covers all kinds of things. Aluminum extrusion isn't just an aluminum extrusion. it could be a window, or it could be a screen door, and still be an aluminum extrusion. As long as it's not quite finished, it's still an extrusion, even if the value of the aluminum is only a fraction of the total value. And this is a wonderful case. I wish I had thought of writing all my scope this way. It's also generated a huge amount of both decisions from the Commerce Department and litigation. What it teaches, though, is that the Commerce Department is not, as a petitioner, appealing to them. They're not a pushover. Okay? They actually apply a set of principles and sit in judgment.
You seem so surprised.
I am.
What is that?
Yeah. So even if you're a Whig, you still have to have, I just love this because, you know, my hairdo, right? So you still have to have facts in the law and apply it, right? Just as you see in all the decisions. And the Commerce Department and the level down below the legislation, or down, different, implementing it, also is applying the same balance, right? There's not this, you might think, bias. Despite the changing times, both the departments and the ITC and the courts also keep maintaining this balance. And you see that long-term in the decisions. If you were to look, for example, at ITC decisions over 30 years, the negative to positive balance, when did they go affirmative? When did they go negative? It's almost 50-50. I mean, it's right there. Now, the same thing, the Commerce Department, they have some invisible compass in their mind, somebody's mind in there. There's an ideal dumping law, and they've been kind of trying to implement this for years. And so when the courts or the Congress or the parties argue in a certain way and tilt the balance a little bit, Commerce always trues back up, because somewhere there's this is my theory, somewhere there's this guiding principle held by the gurus inside Commerce. So what happens then is you'll get cases like the steel cases. Right now we're in the midst of these big steel cases. Right now we're in this hot political environment. We have an election coming. In an election year, there's a lot of pressure. Steelworkers have a lot of votes. They want to win their cases, right? So you get pressure, and the Commerce Department is still trying to apply the rules fairly, right? And so what happens then is you get litigation. And that's when the courts come in and they can say, look, you went too far on one side or the other. In the court's view, in recent case this year, Hughes Steel 16-76 CIT, Commerce went too far in calculating constructive value profit. And that's a technical thing, but what that means is the dumping rate they calculated on oil country tubular goods from Korea, the court thought it was too high. It needs to be lower. You pull the number out of the air, go back and tell us, give us a better reason for the number, more or less. So the decisions currently and the cases, so steel is one, and that's an example of a whole raft of decisions. Another issue for that steel cases is at the ITC, and there again you see this balance that I'm talking about, essentially win-loss record when you're a litigant. Then we move from those decisions to the WTO. Now you heard in the first panel, international trade law in the U.S. is a U.S. construct, right? It's U.S. statutes. I do the same thing as essentially like a tax lawyer, right? I apply U.S. law. That's what I argue. So sitting somewhere out there beside, above, whatever, there's another level of review, and this is the WTO. So we signed an international agreement, and we made ourselves, the United States, subject to the dispute settlement mechanism under this WTO. And so the appellate body of the WTO is allowed to review U.S. legal decisions. And last year, in terms of my D.C. update, I can point to two major decisions against both of these agencies, in which, in both cases, the U.S. court has affirmed, sometimes repeatedly, U.S. law, and a WTO appellate body said, well, no, you're wrong. This is inconsistent with the WTO. So there you have a situation where a sovereign government, the United States, through its courts, has repeatedly ruled a certain way. And the WTO appellate body has struck this down. And this issue arose really right after the Uruguay Round Agreements Act, right? I mean, right after it was filed. And I'm getting the signal that I'm going on too long. I think it's interesting because it also shows that whether we tilt the balance in the short term because of one election, one way or the other, right? Whether we, through some legislation, can get the Enforce Act in the law or not, we still have the international agreement out there, and that's pushing in a completely opposite direction, one in which the Whigs, the petitioners, have no standing, right? If I win a dumping case, I can't go to the WTO and appeal because Commerce made some decision and gave me a smaller dumping duty than I think. I can't do that because I'm not the United States, and the United States isn't going to appeal its own decision. So it's a one-way track. Dumping and countervailing duty cases at the WTO level are only going to be overturned. They can't be affirmed. I can't appeal a negative, right? So outside of this balance, we have this, at least from the private practitioner standpoint, this WTO system. And so there I will stop. See my time. Thank you, Professor Colares, for letting us be here. Thank you for listening.
I think this is on. Can you hear me? Okay. First, before I say anything else, I wanted to thank Professor Colares and Melania for making all the travel arrangements. It was very seamless to get up here to be here this morning. And second, and most importantly probably, I have to announce that whatever I say today, these are my own opinions and do not reflect the opinions of the United States Department of Commerce, nor should they be construed to be opinions of the Department of Commerce. So it's interesting to me to listen to Jim talk about balance. If you have been involved in trade at all over the last 3 or 4 years, you will realize that on October 1st of 2013, my client at Commerce underwent a name change. It used to be the Import Administration, which was a noun and easy to write in a brief. And then on October 1st, 2013, the day the government shut down for a month, we were pushing FRs out, the Federal Register notices out the door, to undergo a slight reorganization, but more importantly, a name change. And so now we are a non-noun, enforcement and compliance. And it makes it very difficult to write that in a brief because it's not a noun. So it's, not the Enforcement and Compliance Agency, it's not the Enforcement and Compliance Unit, it's just enforcement and compliance. So the powers that be are interested in enforcement these days. I mean, that is clear. As Jim said, we had a new law passed just last summer, I think it was last summer, and the short name for it is the Enforce Act, and that's a mostly customs-specific law. 2 summers ago, in 2015, we had the Trade Preferences Act passed that has enforcement mechanisms in it. So it's clear that the balance, to the extent there is a balance, and I deem my agency to be like a fulcrum of the balance, it's clear that not that there was never a trend towards enforcement, but the overt trend is towards enforcement of our trade remedies law. And trade remedies is only, like if you had a chessboard, what I do is almost blinkered, right? I mean, I'm just one little tiny piece on the chessboard doing AD/CVD law, or dumping and countervailing duty subsidy law. And others, Dominic's agency does the injury portion of that. Our good friends at Customs and Border Protection, they do the collection of all the duties that we assess. Earlier this morning, somebody asked about shouldn't there, didn't one of the candidates say that we needed a trade prosecutor? I think our colleagues at the U.S. Trade Representative's Office would submit to you that they are the trade prosecutor, right? But the way that they manage trade is they have to look at the whole chessboard. They don't get to just limit their view to just trade remedies. And for those of us in the trade remedies field, it would be really nice if they would limit their view to what's happening over here instead of, in a weird way, kind of selling us down the river for what's happening in the agriculture sector, right? So it is, I mean, trade encompasses a lot of different moving parts in DC. And it's interesting to me because there is slight overlap in some of the agencies, one would think, but it really, in the implementation, there is no overlap. I mean, each agency has its own specific purpose and its own specific statutes and its own specific regulations under which they act and they react to what's happening. I know Professor Collaros indicated earlier today, as did Larry, that if you're interested in international trade, you should take administrative law. That would be extremely helpful to you because on a daily basis, my attorneys, and Heather can attest to this, my colleagues, they go nowhere without their regulations. I came up here with my regulations. I don't know that I'm going to use them. And my statute, because as a trade remedies attorney, you can't go to a meeting without your regs and your statute. You would, be laughed out of our offices because our client at E&C is a bunch of very sophisticated attorneys, economists, just analysts, right? And they are almost more well-versed in the law than the attorneys are. So if you're very new to the office and you come in and you get, obviously, we call it the dog dump. You get the dog dump of cases when you're new to my office. And you go off to your first meeting with our client, they're going to be sitting there with their well-thumbed and well-tabbed regulations looking at you to give them an answer. And you're sitting there going, what do you have in your hand? Oh, that's the regulations, right? So when you're new to the trade remedies area, you really need to, know administrative law. I thought that Jim thought it was interesting that he said out loud that we actually have a principled basis upon which we reach decisions. I find that to be true as well. The statute and the regulations guide us. My client, as I said, is very well versed in the statute and the regulations, and often has its finger on the pulse as things are being drafted for the agencies to implement. That's not to say that every statute that comes out has been run by the agencies. I think occasionally we are surprised by the language that drops from Congress. I was in Geneva last summer and I saw just like a little blurb that some law had been passed. And I was over there on a WTO matter and I was like, well, that's nice. Ignored. I came back to my office in DC and I kept being invited to these meetings. Michelle, aren't you going to come to these meetings on this, this TPFEA? And I'm like, nah, not interested, right? Somebody comes in, aren't you going to come to this meeting? I'm like, why? Why would I? And finally, my deputy comes in and says, because they changed our law. And I was like, oh, like who knew, right? So for about 2 weeks, I was like totally oblivious to the fact that Congress had dropped a new law changing 5 important, 4 for me and 1 for Dominic, aspects of our law. Just dropped out of nowhere, just chunk, right? And here we have new aspects of the law. But for my purposes, the 2015 Act, for our agency's purposes, wasn't that significant because most of the things that got changed weren't really changes. It was just codification of our existing practice, which is great for the agency because then we don't have to fight so hard with the parties and then we don't have to argue so hard at the court because now our practice has been codified as law. The new Enforce Act I see as mostly a customs issue. There is one interesting aspect to that because, as Jim indicated, we have scope cases, which are now, when I started at Commerce, I think the scope cases might have been less than 1% of our cases on an annual basis. And now, I don't know, I want to say 50% of my casework for my attorneys is relegated to scope issues. And I don't know whether that's a function of poorly crafted orders, i.e. aluminum extrusions, or, you might as well just have an order on aluminum, right? I mean, every product that comes in, somebody's arguing it's in or out, and we have to sit there and try to decide as an agency, where does that fit in the whole anti-dumping or countervailing duty order? And so it consumes a lot of time and space for the agency. And this new act over the summer, I would say petitioners were concerned that there was evasion going on and that companies were bringing in products that should be subject to our orders, and instead of classifying them as subject to our orders, they were bringing them in duty-free. And we do see a lot of fraud in the trade remedies context. So now there's a law that Customs has to get involved, and Customs is now required when somebody raises an allegation, or I think if another agency raises the allegation that there's evasion, Customs has to initiate its own investigation about whether that product actually is supposed to be within the scope of a commerce order. I will note that I call it the get out of jail free part of that statute, is that at any point in time, Customs can refer that matter to my agency. And when Customs refers the matter to my agency, all of the deadlines in the statute are told, right? So to the extent that it seems like it's a quick fix and that Customs within a certain amount of time, I think they have a total of 300 days, so a little bit less than a year to do the whole investigation. But at any point in time, once they kick it over to the Commerce Department and we start a scope, if we initiate a scope, I think we have 245 days to do that. So anyway, scope is a big thing for us right now. China 2016 is a huge thing at our agency. Stay tuned. I'm not allowed to talk about that, but stay tuned. That's going to be, that's in all the journals right now. Everybody's wondering what's going to happen, and I suppose something might happen in a few weeks. I think earlier today, Judge Gordon and Larry were talking about what happens when you have a WTO case that goes one way and the court case has found in favor of the agency repeatedly. Zeroing, for instance, over and over again, we won zeroing. We won it with the judges at the CIT. We won it repeatedly at our appellate court, over and over again, zeroing, we won. At the same time that was happening, we were consistently losing, not with the panels at the WTO, but with the appellate body of the WTO. The 6, I don't know whether you said they were higher or lower than everybody, but the 6 members of the appellate body, and I have my own opinion about where they should be in the hierarchy. But what happens is when the agency decides, and it's not a singular decision, right? The law is crafted so that it's in consultation with the Trade Rep's office, it's in consultation with Congress. And so when a decision is made as to whether or not to adopt the findings of the appellate body, you can decide how you're going to do that so you're not retaliated against. And so normally what happens is the WTO decision is a prospective decision. So it'll start from a certain date and go forward. And the agency holds on to the court decisions as, applying retroactively to all of the entries that might have come in prior to that point in time. I think that I've probably exhausted my time. I'm just seeing a little time frame there. So let Dominic continue.
Good to know that there's a time clock there. Good morning. I want to thank everyone for the invitation, for being on the panel with my distinguished colleagues, and for you coming out to listen to us and hopefully learn from us. A couple of things. I'll try to keep my points short, but more responsive, and then we can open it up to some questions. Number one, I think that we have Jim's right. We have 2 presidential candidates who are talking about trade. I would note that we did have that back in '92 with NAFTA, but this is a different type of discussion that's going on about trade in general. But more importantly, with something that Judge Gordon raised this morning, there's ebbs and flows. Okay, if you look at the history of the United States, you'll see where there will be instances where we may become more protectionist, and then there are times where we will move more toward free trade. And in fact, I would say, instead of what Jim said as saying, hello, I'm a protectionist, I'd say I'm bipolar. Because I've played both roles before. I've worked at Dewey Ballantine, which many would argue is nothing but was a protectionist law firm. We would describe it differently at the time. And I've also worked at the U.S. Trade Representative's Office, which is trying to negotiate more open trade. And I've worked for a Republican commissioner who was I feel very balanced, but for a number of years she was writing dissents until she was able to persuade her other colleagues that we should be interpreting law in a different way that would get you a little bit more to the balance of what Jim was referring to as 50-50. I would argue that we're not at 50-50 anymore. Each time that you have a new set of commissioners come in, there's commissioners serve a 9-year term or longer because there's a holdover provision in the statute. And I would argue that there's a learning curve and a comfort level that comes with someone who is sitting making decisions. And I'm sure Judge Gordon would say that too, that a new judge may evolve over time of how he or she is interpreting the law. I'm not saying one's either right or wrong. I'm just saying it's a growth opportunity. A couple other things I would say, and I regret not saying this before, but I will say I am here representing myself and not the agency, so whatever I say is my own views since I've already gone out on a limb. I would also say a couple other things, which is the ITC is in a unique position, but most trade agencies can say that. What's nice about the ITC, having served in both in the executive branch, in a policymaking agency, and also helping out on the congressional side, the ITC doesn't do policy. So we're at a nice juncture, and that's why I've been at the ITC for 15 years, where we provide information and advice to policymakers. The Commission also acts in a quasi-judicial manner. Those are the cases that go before the CIT, or they go before the Federal Circuit if they're on the intellectual property side. And it's a nice kind of intersection between trying to do what's right. You're implementing either statutes or regulations, and you don't have to worry about whether or not you're getting the right policy or whether or not you have to be advocating for the right policy. Now, we advise the policymakers. Our clients are the U.S. Trade Representative, and they're the Ways and Means and Finance Committees of Congress. And they're the policymakers. So they come to us and ask for information and advice. We try to do it in a very independent and nonpartisan way. And hopefully that will inform the policymaking process. Sometimes it does and sometimes it doesn't. I've had many laws dropped upon us where there was little, if any, consultation, and then there are times where we've had extensive consultation with Congress. So I will close up by saying, we all do import injury work here. That's our specialty. The ITC also does other types of trade practice. One is on the intellectual property side. Happy if anyone has questions about that to answer questions. We also, as I said, provide information and advice to policymakers. It's our fact-finding side of the agency. And then we also maintain the harmonized tariff schedule of the United States. So that allows customs to then interpret the HTS and collect the duties at the border. And a new law was just passed enacted in May, a long time coming, which deals with the tariff schedule, which is called the miscellaneous tariff bill. That's what they've always been called, miscellaneous tariff bills, which gives temporary duty suspensions, and that's the long time ago policy idea behind it was if you do not have domestic production of a certain product or you have very minimal production of that product, why should another manufacturer who's importing that product, why should we be collecting tariffs on that? It makes us less competitive as a nation, both helping out our consumers, but also if they turn around and export their products, we're collecting a tax, if you will, on an import which can't or hasn't been manufactured in the United States. Now, they're temporary in nature, usually lasting about 2 years, because you never know if domestic production will start up of that product. Anyway, long story short, there was that process got bogged down in Congress. The last time they passed an MTB was in 2010, and it's completely got bogged down, and they passed a statute in May, which transfers more of the process and makes it more transparent over to us. And we just started implementing that this month, collecting petitions for seeking relief, and then we have to do our analysis and send it up to Congress, and then we'll see whether or not Congress passes it. But anyway, I'm happy to I guess we will engage in our questions of ourselves, and then we will open it up to you and look forward to the discussion.
Can I just ask a question to Jim, and that can motivate the discussions. In my international trade law class, we're covering zeroing now, and I usually do a chart on the board where I write, you know, we have an original a decision on EC Bedlin in 2001, where the appellate body strikes down the application of zeroing in original 80 investigations. Then following that, you have U.S. corrosion resistant steel. It's a sunset review, determination. The appellate body does not hold, basically strikes it down, but not in holding in dicta, the use of zeroing in sunset reviews. Then I believe the next step in the progression is 2005 U.S. laws, regulations, and methodology of zeroing, 2006, where, again, the appellate body strikes down zeroing on administrative reviews. The Department of Commerce, in interim, basically announces that it's no longer doing zeroing in original anti-dumping investigations. Then, of course, you have the courts iterations before the trade courts, and then was it last month already, that the appellate body announces strikes down Department of Commerce's application of zeroing target dumping investigations. Basically, what you see is an erosion, a gradual but sure erosion of the practice of zeroing from the anti-dumping agreement. And clearly, this is not what the United States negotiated. This is not in the language. This is an out-of-control activist, and I've written about this, WTO. I would like to see, beginning with Jim, because I know he's a private practitioner, is more fitted perhaps to mention, discuss. What would be, other than basically barring or the occasional South Korean arbitrator that decides, member of the appellate body, that basically that basically decides to try even issues that are not raised in the terms of reference of a WTO. What else can the United States do?
So, actually, I feel like I did too much talking on our panel. I should let other folks speak. But what could the United States do? So, you're correct that the zeroing issue has this evolution of, which is all downhill in the sense you just can't do it. It used to be the case that everyone did it, not just the U.S., all countries. Bedlinens is EC. Everyone else targets. They all do targeted dumping. In fact, that's where the EC went in the wake of Bedlinens. They started doing targeted dumping. The problem the United States government has is that they are the most transparent. When we apply the law, we are the most transparent jurisdiction. It was observed that we're not civil law jurisdiction. Our law is not just the actual words of the WTO agreement. We implement it in a far more detailed way. Our regulations and our statute are much more into the weeds. And we have disclosure of confidential information and of calculations and lawyers who all fight about this. And so it is much more wide open what we do. It's totally transparent. It's a computer program. And the Commerce Department has strived for objectivity. They have said, let's just have a system, and it doesn't matter. It's not going to be in the eye of the beholder. They are attempting to use a computer program to do a calculation to find, is there a pattern? Are there sales that are targeted and these are more dumped? And we will only zero with respect to those sales. And the appellate body has essentially rejected this on the strength of, in my view, a misapplication of the standard of review, which was written into the dispute settlement mechanism. It was written into the anti-dumping code, I'm sorry. And they've never gotten it right. So what can the United States do? Well, at the immediate level, what they can do is probably there's a path to still zero in targeted dumping. At least as we read the opinion. There's a way to continue doing what we do. The problem that arises is that it's making it harder and harder for the department to do this in this sort of neutral and objective way, because they are forcing them to look at more subjective criteria, which may make it actually more difficult to be fair. And it's interesting because I think the WTO appellate body frequently does not understand these are always double-edged swords. These issues always cut both ways. Anyway, I'm sorry, I talked too much again. So.
Remember, this is my personal opinion. Personal opinion about what the United States can do, or maybe perhaps has been doing. The dispute settlement understanding for the WTO has very short timelines. I mean, if you take a look at it, briefs are due really quickly. I mean, the turnaround time, I think, for the appellate body is like 30 days or some crazy thing for a brief once the opposing counsel files their brief. So the dispute settlement itself is supposed to be wrapped up, in short order because they wanted consistency and predictability. Well, I dare say that parties appearing before the WTO for the past few years have had much lengthier times to brief their cases. We had a case filed, Indonesian paper was filed, I don't know, maybe a year and a half ago, and our briefs were just submitted. So the Secretariat is finding itself scrambling for resources right now, right? Why would that be? Because the WTO is member funded, right? So the members have to fund the WTO, or the WTO doesn't get the resources that it needs to complete its tasks. Now, it just seems interesting to me that the past few years, the WTO Secretariat, the panel Secretariat and the appellate body Secretariat have been overwhelmed with cases and not able to schedule the cases the way they're, on the timing that they're supposed to be able to schedule the cases on. That's not to say anybody's withholding money from them, but it just seems interesting to me that that has been happening over the past few years. And as a beneficiary of the fact that you can have now a longer chance, longer opportunity to get your brief together and file it, I appreciate the longer period of time. But it is very challenging for the agency. And as Jim said, if you go back and you're looking in your class at zeroing, you will see that everybody zeroed at the time the WTO agreements were entered. I mean, that was the norm. And in a prior round, the Tokyo round, I think it was, somebody, I think it was Japan maybe, had a proposition that they cease zeroing, and they write that into the agreement, that they take it, that zeroing come out of the agreements, and that was shot down. So that language was not included in the agreement, right? Because nobody agreed that zeroing would not be allowed. But with respect to the common law and the code country review process, things just don't work the way that those of us in the United States are used to in terms of review.
I'm not going to talk about zeroing, thank goodness. I avoided it when I left Dewey and haven't had to touch it since. But there is an example of a recent WTO appellate body decision that affects my agency, and that deals with what's called cross-cumulation. So when you have, oftentimes when an industry is seeking relief from dumped and subsidized imports, they will bundle together a bunch of countries and file petitions on them. And then under our statute, we are supposed to, if certain provisions are made, we accumulate all the countries together. And likewise, what's termed as cross-accumulation, we accumulate the countries whether they have dumped or subsidized imports. The WTO came out now almost 2 years ago and said you can't do that. So let's take an example of you have 10 countries who are 10 countries, a case with 10 countries, 9 of them are, and I'll make this very simple, 9 of them are dumping, the allegations are for dumping, and 1 country is subsidizing their products. So the idea is that you have to, under the WTO decision, you need to treat do a separate analysis for the subsidized country and don't group them together. I don't think the WTO got it right, but what I will say, okay, I do understand how the U.S. courts, and it was the CIT back in the 1980s, and went to the Federal Circuit later on in the 1980s, I do see how the U.S. courts came to one decision, and I also see how the WTO came to a different decision. So in the U.S. statute, accumulation is a provision that applies both to dumping and to countervailing duties. So it's a standalone section that applies to both. And under the WTO, the agreements were negotiated. So you have the dumping agreement and the subsidy and countervailing duty agreement. Accumulation was inserted in both of those agreements. So again, I don't think that the WTO got it right, but I do understand if you look at the hierarchy of how agreements were drafted or the statutes were drafted, where one could depart. And we'll see. I mean, but we're in a very precarious situation because under U.S. law, we did go back and analyze that one case. It was an India hot roll case separately, and the commission still found that there was injury, so the orders stay in place. But the way the U.S. And the way the WTO decided that case was, this is a one-off case. It'll be interesting to me to see whether or not another country brings a case to the WTO that will be more broad-ranging. And then if the commission were to change its practice, then we'd end up in front of the courts.
We are, again, running a little bit behind, so let's open for a couple of questions from the audience. And I will ask our experts to limit their answers to 1-minute responses at most, so that we can break and make the time during break. Thank you.
Hello. Okay, thanks for your performance sharing. It's very inspiring. My question is about 2012 GPS law. And as we know, in 2012, the Congress already retroactively authorized the Department of Commerce to impose the CVD's duties on NME merchandise. And then Chinese government filed a lawsuit in the CIT, and right now this case has been decided by the Federal Appellate Court. So my question is, what is your opinions about the constitutionality of this law? And could you please share some your experience or opinions about the issues? Thank you.
Sure, that's one of my favorite things. People often ask whether it matters whether there's a Republican or a Democrat as my assistant secretary, and I would point out to you, for GPX, in less than 90 days, the whole Congress acted in concert to change a trade law. All right? And the reason they changed the trade law was because the Federal Circuit, in my opinion, humble opinion, got it wrong and said that for some unknown reason we couldn't apply the CVD law to non-market economy countries. Obviously, the intent of the law and of the Congress was that we could. So within less than 90 days, they got together, they passed a law, the law is in effect, and that's the way the U.S. system works. Is it constitutional? Absolutely. Were some of the judges at the Federal Circuit very pleased with the fact that the law had changed? I don't think it mattered to them. They're charged with applying the law as it stands, and that's just the way it works in the United States. And that it happily worked, in my opinion, the right way. As a person who worked on the case, it happily worked the right way. And Congress was very reactive, all of them. I think it was 97-0. I think the vote on that law.
Just in the interest of time, I'll yield some of my time on the next panel so you can answer this one. Just taking your hats off, in particular as government officials again, do you think AV or anti-dumping CVD practice, what will it look like in 10 years? And the reason I ask that, I mean, for these law students here, will trade remedies practice look the same? Because building off of Jim's comment, I was struck by the balanced comment and then the historical discussion this morning, is if you are trying to save 400 jobs here in the United States through protectionism, well, aluminum extrusions is going to put 400 people out of work about 12 miles down the street that are importing all the finished goods that Home Depot and Lowe's sell out from China. And I'm from Warren, Ohio, by the way. So just a shout out. And NAFTA is not a 4-letter word there, but it's usually preceded or followed by one. But you know, we see that type of, so that's the balancing act that we generally see, right? Winners and losers. But then we also have, in a world of integrated global value chains, where I have, for example, clients that on the one hand, for example, in the solar panel industry, want the inputs to come in duty-free, of course, but then there's protectionism on those. But of course, when they're selling those damn things, they want as protectionism as we can get, and they're screaming at the Canadians about fit and everything else. So it just, I guess my question is, does this model, when we're talking about trading goods, still apply to the 21st century global value chain system? And I'll give you as much time as you want for my next panel.
All right, I'll pretend to answer this question. In 1988, when I was in law school, which was 100 years ago, the big cases back then were the ball bearings cases, right? The Japanese ball bearings cases. And it was the same thing, right? The allegations were that the Japanese companies were literally running the U.S. ball bearings companies out of business. And there were, I mean, for the congressional hearings, they had documents, letters, and not emails, because we didn't even know that that existed. I mean, that was way in the future, right? But they had letters and everything from the Japanese companies basically saying that their purpose was to drive the U.S. ball bearings industry out of business. So, and that obviously was displacing workers, putting ball bearings workers out of business. There, because they had the Defense Act, Made in America, you still had to keep bearings and certain steel products for application in certain defense industry mechanisms. There were still a few companies that managed to survive that. But I don't see that it's any different now than it was then. I mean, there's more globalization in the fact that Jim might be representing a client who, does have a subsidiary that might be an importer, and weirdly, he's supposed to be on the other side of the V at this time, right? It makes it very confusing for me at Commerce, because we used to have petitioning law firms and respondent law firms, and now they kind of like morph. It's hard to understand what's happening. But no, I think that the problems that exist today existed back then. I don't, it was the same thing. Displaced workers, companies going out of business because other countries' products were trying to displace them in our marketplace.
But then you had, just as a rejoinder, that you had Japanese companies and U.S. companies they're
yeah.
Japanese and U.S.
The judge, I know the court struggles with this as well, and I see it, my staff sees this on a daily basis. People come in and we're like, that law firm represents so-and-so. Didn't they represent so-and-so last time? And it really, I have to take myself back 100 years to my ethics class, and I'm like, can they do that? All right, and then your brain's like, well, I guess they must have the right waivers, but can you waive that, right? But my office, luckily for me, we don't have to deal with all the ethics stuff. That's a bar issue, right? So if you don't want the Department of Commerce deciding, which attorneys are ethical and which are not. I mean, we don't have to deal with that. But for attorneys writ large, I mean, that's a question. I share your concern with respect to the attorneys.
So, yeah, I think as the economic models change, there's going to be opportunities for creative lawyering, and there will be opportunities, and the field will morph and adjust to it. I mean, in my comments, I think back to my early part of my career where we were focusing on privatization of state-owned industries in Europe, right? And as I talk through, you go from state-owned industries to privatization, then you go from state-managed economies and state-controlled economies. So I think as the world modifies its economic models, there's going to be plenty of opportunities, and it's going to morph across different sectors and industries. There'll be some expansion at times for opportunities for lawyers and economists in this area, and there's going to be some contraction at times. But I do think that the law in this regard, very candidly, is going to be reactive. It's not going to be ahead of the curve. It's going to have to respond to the driving forces in the economic models in globalization. And that, because lawyers are terribly creative and inventive, will provide opportunities. I was actually going to morph the question and ask the three of you, what opportunities or what thought processes do you see evolving for creative lawyering outside of the normative roles that exists. You know, for example, like enforcement, you see either a key tam action or a private right of action that is going on in the Central District of California, I think, regarding I can't remember whether it's the shrimp or the garlic industry. You see all of these. There was actions in the 337 area as a result of some decision making. The question is, we sit here talk about traditional customs and international trade, but what opportunities exist for lawyers to be creative outside of kind of the normative approach?
Do you want to do 337?
Well, what are you seeing?
So, Your Honor's point, as I would rephrase it perhaps, is that from our perspective as private lawyers, those problems will always be there. In other words, trade friction, right? And so therefore, it's our job to figure out, well, what's the remedy? So if the WTO takes the dumping law away from me, for example, if China at the end of this year has to be treated as a market economy or something like that, we'll just find another remedy. I mean, there are lots of laws. I mean,
You can draft lots of laws.
So in that context, what you are seeing is that people are doing exactly what you're suggesting. There have been actually quite a few key TAM cases, which are perhaps a more effective way of enforcing even than taking something to the Customs Service. There have been a slew of 337 cases which don't just allege a patent violation or a classic sort of palming off, passing off, classic unfair trade, common law, unfair trade cause of action. You're now seeing other types of causes of action. In essence, an antitrust or predatory pricing cause of action, or almost an anti-dumping cause of action being brought as in the guise of or in the form of what you might think of as a common law unfair trade action. And that is kind of the forefront or the cutting edge in a sense of finding.
Versus private party litigation not involving any government agency.
Well, no,
Well,
I'm talking
other
about,
than
this
us.
is that 337. Key TAM.
The key TAM.
Right.
Well, it's government, right? Because you
Justice Department has to
start,
decide.
I, a private party, sue the, right, and then the government comes in and takes over. Well, the idea is they would take over and then I get a third or whatever, right? So.
It's a very lucrative business to be a relator or moiety in a key TAM action. But Dominic has a very interesting 337 case, so if he wants to talk about it, it's very interesting.
Sure. Well, I guess I'd like to say a couple of things. Number one, as it, I think, always has been, it still is. It's a great time to be a lawyer. Okay, because every time that, and I've been doing import injury cases for a long time, and every time you say, oh, I think we've come to the last interesting type of issue, then something else crops up. So that's where a lawyer who is well versed in all different practices of law and who is creative can challenge an agency, can challenge an idea, or can challenge a law, and you may be able to open up a new practice area. So that's number one. Number two, kind of getting back to your question, import injury, AD/CVD, I'm not worried about going away. Okay, I know there's been a lot of talk about that. Number one, I would say there have been the caseload at my agency is as high as it has been in over 15 years. It was back in 2001 when we had a slew of dump countervail cases filed, plus the Still 201 filed, that we haven't been as busy as we are now. And more importantly, I don't care what I do care, but I should say I don't really care too much about what the WTO does, because you just see every other country out there using dump countervail right now. In fact, one of the issues that we have going on as a country is how much do we pursue what other countries are doing, implementing their dump countervail laws. And then on the 337 case, is it a new, there have been a couple still 337 cases filed. There's a big one that was filed this summer. It is ongoing, and as Jim referenced, it does involve 3 different concepts. One is dealing with antitrust or price fixing, which one could, analogize to a dump countervail. I need to be careful about that because if it is, then it goes over to commerce.
We quickly kicked it back to him.
Yeah, well. But there's the trade secret theft, and if you think about globalized companies, what you're seeing more and more of nowadays, and what we're seeing more cases of, is not necessarily a infringement of a patent. It's that the trade secrets have moved overseas. It happens inside a country, but in this case, to bring a complaint under 337 has had to have moved overseas. And then the third one is the false designation of origin, which gets into the traditional kind of customs areas. It will be fascinating to see how it plays out. I know that a lot of people who have been involved in the traditional dump countervail side of the bar is wondering whether this will be a new way to go. And time will see. The commission will. The ALJ that's been assigned to will hold her first hearing on on the trade secret theft in April, and then on the other two matters in August. And her opinion is due out November 2nd of next year, and then the commission's decision is due out March of the following year. But anyway.
Can I just end one question? I apologize. You asked about the constitutionality of the GPX decision, and this is going to worry me all the way home, so I'll have to say this. The mandate for the Federal Circuit had not yet dropped. Okay, so the Federal Circuit's decision was not yet final when the law changed. Okay, so that is why the change in law was constitutional, and that's why the Federal Circuit had to follow the law. Okay, I apologize. I should have said that earlier. That was been worrying me.
With that clarification, we're running a little bit behind. Let's take a 5-minute break and then rejoin for our last panel of particular importance to our students. Thank you.